You guys are warm, huh? Oh. Okay, I'm ready. بسم الله الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه ثم أما بعد. So inshallah today we will try to finish some of the guidelines and benefits about al-'ada muhakkama, the guidelines and benefits that pertain to the legal maxim al-'ada muhakkama, or custom is authoritative. Custom is authoritative. So remember last time we were talking about the meaning of al-'ada, the meaning of al-'urf, and the difference between al-'ada and 'urf, and whether we give precedence to al-'ada, habit, or al-'urf. And the bottom line was what? Al-'ada is basically the habit of one or two people or a smaller group of people. Al-'urf would be the habit of a community. And so now you call it a custom or customary practices when it is the habit of a community. But if it is your habit, my habit, then it's just called the 'ada, our habit. So today, inshallah, we'll be talking about a couple of other guidelines in the understanding. And remember last time I told you that we'll start today to talk about majalat amal al-Qa'ida, which is basically the spectrum of its operation or the scope of operation. So we will defer this until next time. And today we will be talking about two important issues. And this would help us, inshallah, when we address majalat amal al-Qa'ida, or scope of operation of the maxim. One of them is the relationship between the revelatory designation, that is al-wad' al-shar'i, the meanings of the word in the revelation. What does the revelation imply or mean when it talks about salah, when it talks about sariq, etc.? The meaning of the words in the revelation, this is called al-wad' al-shar'i. Al-wad' al-shar'i, or the revelatory. Sometimes they translate it as legal. I think I will try to stick with revelatory or al-wad' al-shar'i, particularly in that context. Because Sharia could be translated as legal, but Sharia within that particular context, I think it is more like revelatory. Sharia in the sense of what the Sharia, the lawgiver, indicates when he uses this word. So revelatory would be better. Al-wad' al-shar'i would be the revelatory designation. Al-wad' al-lughwi would be the linguistic designation. Wada is basically what the people of this language mean, the meaning designated to this word by the people of this language. That is why they call it wada. When tada, to put, tada, when I ada this on the table, I put it on the table, I place it on the table, I put it on the table. So al-wada is, in this context, usually it means in this context designation. So I designated this particular meaning to this particular word. So it could be the designation is coming from God, revelatory. The designation is coming from the people who speak this language in their sort of in the purest sense of linguistic definition. Then it is called wad' lughawi, or linguistic designation. The designation is coming from the people who used this language, who use it now. Like sometimes the difference between the usage of the people who first used the language and people who come 2,000 years later or 5,000 years later and still are using the same language, but the difference could be huge. something could be like a compliment 2,000 years ago, and it would be an insult now. So this is called al-wada' al-urfi now, customary designation. So I have the revelatory designation by God, linguistic designation by the first use of this word in this language, whatever the language means, whatever this word means in that language. And then I have a customary designation, what people use this word to indicate in their actual lives, in their daily practices. So today we will talk about the relationship of the three. And so we talked before, and we said before that al-wada' al-shar'i, that al-urf will have to comply with the shara. We're not saying al-'ada muhakkama to circumvent the sharia, to circumvent the divine law, the a'raf of the people that are basically oppositional to the sharia or diversion from the sharia will need to be adapted to the sharia if they cannot be reconciled with the sharia. They need to be adapted to the sharia and they need to be in conformity with the sharia. It is only natural that we conform to the divine, not the other way around. It's only natural that we conform to the demands of the divine, not the other way around. So, but what if there is a conflict between the three different designations? There is a conflict between the three different designations. What do we do in this case? And through the examples, we will be able to tell what this means. So what we said before, one of the qawa'id that we will study is that which is not defined by the Sharia or the lugha, that which is not defined by the Sharia or the language will be defined by the urf, the customs. Okay? Well, I agree with this to a great extent, but the disagreement happens when there is a conflict between the different designations. So let's begin with saying that if the Sharia mentions a particular matter, and attaches a ruling to it without defining it, then we will refer first to the lugha. The first thing is to refer to the lugha. It makes perfect sense. إِنَّا جَعَلْنَاهُ قُرْآنًا عَرَبِيًّا. We have made it like an Arabic Quran. It is the law has been revealed in the language of the Arabs. The first audience were the Arabs. Therefore, to understand the law, then it has to be understood within that context. So within the context of the Arabic language. And then, if the lugha is not decisive, so the word is sariq, for instance, the word sariq will be understood through the lugha. But the lugha sometimes may not be decisive. The word hirz is a safe place to safeguard your property, your valuables. A safe place to safeguard your properties. Hirz, so why do we need to figure out what hirz means? Because if you steal from a non-hirz, you will not be subject to the had of sariqa, to the prescribed punishment. You may be subject to some punishment, but you're not going to be subject to the punishment, to the fixed punishment of sariqa. You're not going to have your hand cut off. If you steal from a non-hirz, or if you take a property that is not yours, a property that, like, you find something in the street, for instance, and you take it, is this to some extent sariqa? Yeah, but is it sariqa from a hirz? No, because that whatever the property is should have been kept in a safe place. What is the safe place for different types of properties? it varies with customs. It varies even within the same custom, among different properties. So not every property, if I leave with you, for instance, gold, and you keep it in your closet, you just keep it in your closet, then I have the right to ask you, is that a proper place to safeguard gold or not? And it depends on the urf, and it depends on the customs. If it is not a proper place, then you will be liable. Although you were entrusted with the gold, but so it's called yad al-amin, which is you are entrusted, therefore you should not be liable unless you have committed a form of transgression or negligence, ta'addi or tafreet, but you will be liable in this case because you did not keep it in a proper sort of herz for that particular item. Therefore, we need to figure out what herz is, because the had will depend on it, the liability will depend on it, so many things will depend on it. So go to the Quran and the Sunnah to define herz. You don't find the definition, then go to the language to define herz. It will tell you it's a safe place, but what do you mean by that? So ahrazahu means protected it. It is a place where you can protect something. But what do you exactly mean? That has to be defined by the urf. Customary practices will define what is a safe place to keep, your grains, and a safe place to keep your gold, and a safe place to keep this and that. Okay, so then the Sharia will not only, it's not only that sometimes we don't find a definition in the Sharia or in the language, so we resort to urf. The Sharia sometimes the Sharia tells us resort to urf. The Sharia itself tells us resort to urf. Yeah, when Allah subhanahu wa ta'ala says, وَعَاشِرُهُنَّ بِالْمَعْرُوفِ, live to them according to, sometimes we translate al-ma'ruf, and we talked about this so many times, as reason, according to reason. Ma'ruf would also mean according to what is customary, according to that which is customary. So reasonable, customary, or good, all of them mean al-ma'ruf. Al-ma'ruf is a mixture of all, because customary is usually reasonable. Customary, like people, like a community of reasonable people will not have basically a bad custom or an unreasonable custom. So that is why they all sort of overlap, customary, reasonable, and good. So عاشرهن بالمعروف, the Sharia itself is referring us back to al-urf. خذي ما يكفيك وولدك بالمعروف. When Abu Sufyan says to Hind, take what is sufficient for you and your kids according to ma'ruf, according to that which is good, reasonable, customary. Good, reasonable, customary. The Prophet ﷺ is not telling Hind how much to take. Is not telling her what it is. He is himself referring her back to customs. Okay, so this pertains to what? Or this discussion pertains to what? This discussion pertains to finding proper definition for terms that have been used by the Sharia and for which we cannot find a particular Shara'i revelatory definition or linguistic definition. But what about human speech? Not the revelatory address, but human speech. So when revelatory, linguistic, and customary meanings diverge, should we take human beings by the revelatory, the linguistic or the customary. If the expression is one upon which a legal ruling depends, then the Shari'i designation will be given precedence. The Shari'i designation will basically override the other. So if I say, I will pray after Asr, or I'll pray after Maghrib, or I will not pray if I make a vow not to pray, what does this vow pertain to? Prayer in the language means connection. But since this is a word that has been clearly defined by the Sharia, upon which Shari'i rulings rely, and it is defined by the Sharia, therefore the revelatory designation will always be given precedence. So the salah here, when I make a vow not to pray, will pertain to not dua, which could be salah in the language, but that particular act of worship that starts by taslim, by takbir, and ends by taslim, and requires wudu, and so on and so forth. Now, if it is not tied to a legal ruling, if it is not tied to a legal ruling, I will just talk about something that is not clearly defined by the Sharia, not tied to a legal ruling. Then Ibn Rajab has outlined two legal maxims regarding the specification of the general terms by means of urf and ada. Maxim 121, the 121st maxim of al-Qawaaid al-Rajabiyya, which, as you may have seen, we rely on so much, because when it comes to al-Qawaaid al-Fiqhiyya in the Hanbali madhab, the closest book to being a book of Qawaaid would be the book of Ibn Rajab. The reason why we didn't go over the book of Ibn Rajab is because it is not always about Qawaaid, and it is not arranged in the usual way Qawaaid are arranged, and it doesn't cover all the Qawaaid, and it is to a great extent about dawabit more than Qawaaid, and so on. But certainly it is the closest book to Qawaaid Fiqhiyya in the madhab, that was written by one of its earlier scholars. So he says, on the specification of general terms by custom, there are two scenarios. The first scenario is that the general term has come to be predominantly used for some of its reference. We now have a haqiqa urfiyya. A customary designation, a customary reality which is different from the linguistic reality. Such as dabba became, a beast of burden, but dabba means anything that walks, but it became in the customary usage pertinent to beasts of burden in particular. So we now have a haqiqa urfiyya. Other examples, in this case, the haqiqa urfiyya will take precedence. He is saying that it's not disputed then that when to basically interpret the speech of people, we will go to al-haqiqa al-urfiyya, not al-haqiqa al-lughawiyya, not the linguistic designation, the customary designation, such as in dabba. And he mentions also roof, lamp, peg. Roof is, saqf. The Quran refers to the heavens as a roof. The lamp is siraj. The Quran refers to sun as siraj. Pig is watad. The Quran refers to mountains as autad. Will this Quranic usage be used, favored over the customary usage, or the customary usage favored over the Quranic usage? He says it's undisputed that the customary usage will be favored in understanding the speech of people, because people are not basically, when people are speaking, they're not given attention to the Quranic usage. They're giving attention to the customary usage because I want to speak to you, to communicate a message that you could understand. So there is basically an established convention, between me and you as members of this society. As members of this society, there is an established convention that when I talk about saqf, I mean something like this, this roof. I'm not talking about the heavens. Or when I talk about, siraj, I mean, a lamp, not the sun, and so on. Then the term has not become a customary, has not, the customary designation is not consistent yet. We don't have a customary designation that is used all the time. So there is no haqiqa urfiyya that is consistent. So he says that which is never referred to by the general term without qualification and never independently, such things are not included within the general term. So in Arabic, because these examples are usually, like we say rose water. Rose water is ma al-ward, ma al-ward. So is rose water included under ma when I speak about ma, when I speak about water? Is rose water included or not? So it will not be included. When we say in Arabic tamr hindi, that's Indian tamarind. Tamr hindi is Indian tamarind. Is tamr hindi included under the different types of dates? No, it is not. Although linguistically it would be, it means Indian dates. Like if you just literally translate tamr hindi, and probably some people do literally translate things, so it will be Indian dates, but it is Indian tamarind, and so it would not be included. There is something called khiyar shambar also, like cenapods, that's not cucumbers, that would not be included under cucumbers. And then the second type, that which is included under the general term, but typically only when accompanied by a qualifier. So the first one, certainly rosewater and tamr hindi will not be included under water and dates. The second one is a little bit different, and that is why you will have disagreement within the madhab and disagreement among the scholars in general. So the term is, you usually have a qualifier. You usually have a qualifier, but the qualifier is not always consistent. So let me give you like an example. For instance, on this is someone who swears not to eat heads, ru'us. The examples are usually relevant to the culture. So, like if you go to a restaurant in basically countryside in Egypt or certain areas, it's usually not in it's not everywhere. It is certain areas, certain areas where there is certain socioeconomic standard. Then and you tell them I want a ras, a head. So what does this refer to? And is it consequential to the rulings? Yes, it is consequential, because sometimes you could vow not to eat a head or not to eat ru'us, not to eat heads. If you vowed not to eat heads, what does that mean? Does that include the head of fish? For instance, does not include the head of gazelles? Or is it does it only pertain to the heads of sheep? So there will be disagreement here. So al-Qadi says it's eating anything that's called a head, eating any head. Abu al-Khattab says you only violate the oath by eating a head that is customarily eating on its own. Customarily eaten on its own, not the head of the fish, because you usually don't eat the head of the fish unless you eat the fish, and you eat some of the head of the fish if you like. But It's not customarily eaten on its own. In al-Targhib, he says he basically takes the position of Abu al-Khattab. It's only heads that are customarily eaten on their own, and he basically sheds light on the importance of particular customs, specific customs of specific communities. And he says, if selling gazelle heads individually is known in some communities, then you will break your vow by eating those heads. Otherwise, you would have not broken your vow. So here he's applying what? Local custom. So is local custom applicable? Yes, local custom is applicable, because that's a huge discussion in usul and in Qawaaid about whether the custom needs to be a general custom or local customs also could be applicable. If there is a consistent local custom and we're talking about people from that community, then it will apply to them. The local custom will apply to them. So if you say that you will not eat meat, lahm, if you will not say you vow to not eat meat, will it apply to fish? Here in the Hanbali madhab, they basically decided that it will apply to fish. In other madhab, they say no, it doesn't apply to fish, because it is not customary for people to refer to fish as meat. So when you want to eat fish, like here, for instance, like you will say seafood. Let's go out and eat seafood. But if I call you up and say, let's go out and eat meat, and then I invite you to a seafood restaurant, and then I tell you it's meat, Allah called it meat, lahman tariyan, tender meat. So will you be disappointed? Or you will say, no, I just don't eat fish, I have allergies or something. I didn't understand that you meant fish. I thought that you meant meat. So in the Hanbali madhab, they say, if you vow not to eat meat, you cannot eat fish. Anyway, so that is a little bit of an issue here. It's the mu'tamad of the madhab. Is there a disagreement within the madhab? Yes, of course there is a disagreement within the madhab, but it is the mu'tamad of the madhab. So the 122nd legal maxim is about the general am, whether it's specified by the custom ada, even in cases of explicit wording. And so if you bequeath a property to your relatives, or a sum of money to your relatives or to your household, to your aqarib or ahl baytik. Relatives, aqarib. Household, ahl baytik. What does that refer to? Because aqarib could be the whole tribe, It could actually be humanity, since you all come from Adam. So, but what does that refer to? And Imam Ahmad said it will refer to the people that you used to extend kindness to, or that you used to basically visit with your aqarib. So if you have, like 200 aqarib, 20 of them you used to connect with, you used to basically visit with, show kindness to, then it will apply to those aqarib. Here we specify the general term by the ada, by your habit. We specify the general term by your habit. Is this a matter of disagreement within the madhab? Yes, it is a matter of disagreement within the madhab. And they disagreed, but this is the mu'tamad. The mu'tamad is that we will basically take in consideration your habit. We will take in consideration your habit. But some people also reported another narration from Ahmad where he was told about someone who had relatives in Baghdad and relatives elsewhere, far away, in his homeland. And he used to basically be kind to the relatives of in Baghdad. And he used to support the ones in Baghdad in particular. And then, well, his sort of designation of aqarib apply to the relatives in Baghdad only or the relatives everywhere. And Imam Ahmad said everywhere, all of his relatives. So that Ibn Abi Musa, I think, felt that this is another narration from Ahmad that is in conflict with the first narration, that we will take in consideration your habit, because he's saying all his relatives, regardless. So Ibn Rajab, however, says that in my view, there is no conflict, because in my view, he was basically connecting with his relatives in Baghdad, or not connecting with his relatives in his homeland because of inability. You know, distance was the factor, not that he liked the relatives in Baghdad more than the relatives in his homeland. It's just the distance was the factor. So yes, the position of the madhab is that we give consideration to your habit, Keep in mind that these things may sound very abstract to you, but if you are dealing with qada and tahkim, arbitration, mediation between the people, these concepts should be basically inculcated, engraved in your mind, because you will need this. You will need all of this to issue proper sound judgment. Okay, so now you have to know. Let's get to a summary now. Let's try to figure out a summary now. How do we understand people's speech? When you make a vow, in our madhab, if you had a particular intention, we will give precedence to your intention, and that's the Malikis as well. That is not the Shafi'is or Hanafis. If you make a particular vow, does your intention specify the generality of the vow? Malikis and Hanbalis, yes. Your intention specifies the generality of the vow. So we will give precedence all the time to your intention. So if you say, anything. If you say, I will not speak to my relatives, and you meant a particular family out of all of your relatives, is your vow pertaining to that particular family? Keep in mind, you didn't utter any word except that I will not speak to my relatives. But you intended you will not speak to that particular subset of relatives. Your intention will be considered in our madhab, and it will specify the generality of relatives. Okay. However, at times, the intention may not be known, even to you. You just said it, and we don't know, you just said it, but you didn't have any particular intention. So how do we judge between the competing meanings in this case? So upon examining the rulings, that's my summary, two guiding principles emerge. One of them is given precedent to the dominant meaning. Dominant meaning in Salah and Zakah and Sawm is what? The revelatory. The dominant meaning in Salah and Zakah and Sawm is revelatory. Keep in mind, all of these words have a linguistic meaning that is not the revelatory meaning. Salah is dua, Sawm is imsak, to withhold, and Zakah is basically growth and stuff like this, and purification. But certainly the dominant meanings are the revelatory meanings among us Muslims. Then you will give precedent to the linguistic indication over erratic customary usage. Erratic customary usage. Give precedence to the language until the customary usage becomes consistent and dominant, then you will give precedence to that when it is consistent and dominant. But if you have erratic customary usage, then still the language will overrule. The language will overrule. The second principle is that distinguishing between fatwa and judicial rulings in disputes. In the context of disputes and the interpretation of contracts, general custom is prioritized. So we've gone over this before. If this is a matter of judging, if this is a matter of settling a dispute, the general custom will be given preference because that is the convention between me and you. That is the established convention. We are members of this society. We're members of this community. This community has ongoing conventions. Then we will judge my, discourse, the discourse between me and you, and the interactions between me and you. All of this will be judged within the context of the conventions of our community. Our community. So customary usage here will be prioritized over linguistic usage if it is consistent and dominant. Customary usage is consistent and dominant. But if the issue is not about a dispute, it's not about judging between two different people, the issue is about sorting out your intention, sorting out what you meant. There is no conflict here, there is no judgment. Should we prioritize customary usage or prioritize your intent and your habit? So we will customize your intent first, and then prioritize your intent first, and then your habit, your particular personal habit. So in things like awqaf, like oaths, like vows, like awqaf, what do we prioritize? You make a waqf. What should I prioritize? You make an oath. You make a vow. What should I prioritize? Your intention first. Your personal habit second. If I don't know your intention, I will refer to your habit. I'll refer to your habit. What did you usually mean by this? What did you, in particular, not the customary usage, what did you used to mean by this? When you talked about your relatives, what did you usually mean by this? Because, like I said, all of the children of Adam are our relatives, but certainly we were not going to go this far. We've talked about this before, right? When we talked, yeah. But at any rate, we will go by your intent, then go by your personal habit, then go by customary usage, because we're expecting you to speak within the conventions of your people. First, your intention. Second, your habit. Third, your people's habit. Third, the language. Third, last, the language. Okay. Then next is, so it's clear now. Let me try to did this summary made it clear now what to prioritize? Yeah. So there are differences. There are certain revelatory words that we should never have second thoughts about. Like salah and zakat became dominant. That's it. They became dominant over any haqiqa, urfiyya, customary truth or implication, or haqiqa, lughawiyya, linguistic implication. And then we will have to figure out, is this a matter of dispute where customary usage of the people is prioritized over personal habit of the person, or is it that we're trying to figure out the intent of that person, and then we will go by, his intent if he had one, if he knows what he meant, and then his personal habit, and then customary usage, and then the language. So conditions for applying عادة and عرف, شروط العمل بالعادة والعرف. Like I said, we have to have conditions. We have to have conditions because the phrasing of this qaida can be misunderstood. العادة محكمة. Custom is authoritative. Custom is authoritative. That you know, unless you basically unless you understand the سعة اللغة, unless you understand the flexibility of language, you may find this repulsive, because what you mean custom is authoritative? Didn't the whole thing, you know, the whole thing about deen and, you know, Sharia and wahi and all of that, all of this came basically to change people's customs, to overrule people's customs, so that custom is basically custom is ruled by, governed by the Sharia, not the other way around. So it is not muhakkama, it is not authoritative, it is basically compliant, it must comply, it must conform to the Sharia. So, you know, the phrasing is fine as long as you understand the conditions, the context of application of this particular qaida or maxim. So the IIFA, which is, you know, the International Islamic Fiqh Academy. International Islamic Fiqh Academy is the largest fiqhi body in the Muslim world. And, you know, and people who are skeptical about all forms of authority, people who are skeptical about which is like a trend among the youth. Usually the youth would be sort of rebellious against any form of authority and stuff like this, whether you're religious or not religious. But if you're religious, you will manifest it in a certain way. If you're not religious, you may manifest it in a different way, but it is the same disease. You know, that you know, it may not always be a disease, but it's the same problem. The same problem is that youthful people are rebellious against authority and convention. Sometimes it could be helpful, but, you know, sometimes it could be harmful. So people usually, like, you know, you hear some like International Islamic Fiqh Academy, this belongs to the OIC, Organization of Islamic Conference. It used to be Organization of Islamic Conference, it's now Organization of Islamic Cooperation, which is the sort of the designation that I like a lot more, because it takes the, you know, it's منظمة التعاون الإسلامي. It used to be منظمة المؤتمر الإسلامي, you know, Organization of Islamic Conference, منظمة المؤتمر الإسلامي, or Islamic Conference. You know, there's Indian Conference as well, right? There was like, yeah, but so this was the Islamic Conference. But then they did away with the conference thing, and they called it منظمة التعاون الإسلامي, the Organization of Islamic Cooperation. And like I said, it's much better because ta'awun is a concept that comes out of the Quran. تعاونوا على البر والتقوى ولا تعاونوا على الإثم والعدوان. Help each other on goodness and piety. So the International Islamic Fiqh Academy belongs to the OIC. Naturally, for some of the younger people, they will be sort of averse to anything that represents authority, and the OIC organization is like 59 Muslim states, and these are the kings and monarchs and presidents and princes and all of that stuff. They made that organization, and now they have like an International Islamic Fiqh Academy. It should be a tool for them to subjugate us and subdue us and brainwash us and gaslight us and all of that stuff. So then you basically throw all those great scholars who sit on that council in the trash can, and that is detrimental. You know, that's detrimental when we have this much distrust among ourselves as an ummah. That's detrimental. It doesn't mean that the International Islamic Fiqh Academy is ma'soom. Absolutely not. It doesn't mean that you will have to say, you know, like we listen and we obey, سمعنا وأطعنا, like you do to say to the Prophet sallallahu alaihi wasallam. But it just means that you will have to have some decency and respect for authority, for scholarship, and these are scholars, and they are important scholars. So anyway, give attention to what comes out of the Islamic International Fiqh Academy. Familiarize yourself with, to refer to the International Islamic Fiqh Academy. And if you want to say, well, when it comes to politics and things like that, I feel uncomfortable, that's fine. But when it comes, you know, it's up to you. But when it comes to transactions, when it comes to ibadat, when it comes to muamalat, there is a wealth of information. And you know, you cannot afford to neglect all that. You cannot afford to neglect all that. So here is their basically resolution number 9 of the International Islamic Fiqh Academy regarding urf. Regarding urf, they said the Council of the Islamic Fiqh Academy, having reviewed the research papers submitted by the members and experts on the subject of urf, which is custom, and after listening to the discussions thereon, resolved the following. 1, what is meant by urf is what people are accustomed to and regularly practice in speech, action, or omission. Speech, action, or omission. You know, pay attention to the precision of the wording, because here he's telling you urf does not only apply to speech and action, but it also applies to omission. Tark. It may be either recognized by the Sharia or not. That urf may be either recognized by the Sharia or not. A urf that is in conflict with the Sharia throws it away, of course, and overrules it. Second, if the urf is specific, it is binding upon those to whom it applies. If it is general, it is binding upon all. So here they chose, and the reason why I brought this, because this is consistent with our madhab and consistent with the majority. This resolution, as I say in the beginning, is consistent with our madhab, consistent with the majority as well. So if the urf is specific, it's still binding. But binding to whom? Binding to the, you know, pertinent subjects. You know, if there is a particular urf among a particular profession, does not apply to other profession. There's a particular urf among taxi drivers in New York City that doesn't apply to taxi drivers in Ohio, for instance, and things like that. But it applies to taxi drivers in New York City. If it is general, it's binding upon all. The urf recognized by the Sharia is that which fulfills the following conditions. 1, it must not contradict the Sharia. If it conflicts with a textual provision or a legal maxim of the Sharia, it is deemed invalid. If it is in conflict with a textual provision or a legal maxim of the Sharia, it is deemed invalid. So that is why people who say, you know, what do you mean al-'ada muhakkama? So what if people got accustomed to sin, ma'asiyah, accustomed to drinking, accustomed to like boyfriend, girlfriend culture, accustomed to things of that nature? Will that be muhakkama? Of course not. Nobody is saying this. You just didn't sit down and listen enough to. Anyway, so then it must be continuous. It must be persistent or predominant. Like continuous, meaning persistent or predominant. Predominant is why they say or predominant. Predominant means ghalib. And one of the legal maxims that we have is al-ibra bil-ghalib. Consideration is given to that which is predominant. Because you will always find the sort of the few weirdos that will not basically follow like convention, that who will not follow convention. But should we basically bend everything because there will always be a couple of people out there that are just, you know, on their own? No, we will basically go by Dominant convention, predominant convention. The urf must be in effect at the time the legal act is concluded. The urf must be in effect at the time the legal. You cannot judge me if we have a contract in 1975. You cannot judge me, or you cannot basically reference the customs of people in 1984. You know, if the custom was not established before the 1975, you know, I'm not subject to it. Okay, then it must not be explicitly negated by the contracting parties. Must not be explicitly negated by the contracting parties. If they stipulate otherwise, it is not considered. So, shart and urf, we will basically discuss a very important and very sensitive subsidiary maxim, very sensitive subsidiary maxim that says al-ma'ruf urfan kal-mashrut shartan. That which is basically known through customs is like that which is stipulated as a condition. So it gives the urf the power of shart conditions, stipulations, which means what? You know, it gives urf like huge power. But at the same time, it is the qaida itself is telling you what? That stipulation conditions, shurut, are much more powerful, because we will upgrade the urf to shart, where we say al-ma'ruf urfan kal-mashrut shartan. What if they conflict? We're upgrading the urf to shart. So we will say the contract, you know, the contract, if there are no stipulations, but there is an established convention, that convention will be treated like it was stipulated in the contract. That convention, you know, among the people will be treated as if it is stipulated in the contract that doesn't have stipulations. But what if the contract has stipulations? Then we throw away the convention. You and I wrote in the contract that this is, you know, what we agree on. Should we care about the conventions of the community if the contract between you and I has stipulations, or between you and me has stipulations? No, we should not care about customs. We should not care about conventions. We stipulated what we want. Okay, so it must not be explicitly negated by the contracting parties. The last point in the resolution is a jurist, whether acting as a mufti or a judge, must not adhere rigidly to what is transmitted in the books of the jurists without taking into account the changing customs. Now, you may say that this is new age stuff, and this is the International Islamic Fiqh Academy, and people who are just like sellouts, they're trying to adapt to modernity and all of that stuff. But these are the very statements of people like al-Qarafi and Ibn al-Qayyim. The Imams Ibn al-Qayyim and Qarafi, they actually borrowed their statement and just sort of almost verbatim put their statement into the resolution. This is not something they made up. This is something that they have taken from great earlier Imams. Okay, so the second condition, which is that if urf is specific, it is binding upon those whom it applies to. The second condition, you know, it must be continuous, persistent, persistent or predominant. There is a particular qaida that basically spells out the second condition. It must be consistent or predominant, which is that a custom is only valid if it is consistent. إذا اضطردت. اضطردت means consistency. مضطردة means consistent. Okay, the third of these four that they mentioned, third would be the urf must be in effect at the time the legal act is concluded, it corresponds to a qaida that says the urf that determines the meaning of expressions is that which is concurrent or prior, not subsequent. Concurrent or prior, not subsequent. The contract was in 1975. The urf has to be established then, 1975 or before, not 1984, not subsequent. And this principle applies to understanding both the divine address and human speech and transactions. So that brings us to the end of this, and next time, inshallah, and this time is for real, next time, inshallah, we will go over majalat amal al-Qaida, fields of application, scope of operation, however you want to translate this. Majalat amal al-Qaida. And we said last time that majalat amal al-Qaida is what? One is فهم إطلاقات الشرع وضبط ما لم يضبطه. Understanding the general statement of the Sharia and regulating what the Sharia has not regulated. Lots of things the Sharia has not regulated, left it for customs. And وَمَا كَانَ رَبُّكَ نَسِيًّا, and your Lord was not ever forgetful. Your Lord did not regulate them for a reason, because they ought to be left for customs. Because al-'ada طبيعة ثانية. People's habits and customs are a second nature. The 'ada has power. So the Sharia wanted to leave room for people's customs, so they didn't regulate certain things because they just ought to be left unregulated. Ought to be left unregulated. You see how many hadith we have in Bulugh al-Maram? Like if you go to Bulugh al-Maram and you try to figure out the number of hadith on ibadat, we've covered this before when we were talking about Umdat al-Fiqh, and we're talking about al-ibadat versus al-mu'amalat. The amount of regulation in the area of ibadat worship far, far, far exceeds the amount of regulations in the area of al-mu'amalat. You have like an area like marriage, for instance. It's less regulated than al-ibadat because there is room for customs. We've said, عاشروهن بالمعروف, خذي ما يكفيك وولدك بالمعروف. It is less regulated than ibadat. In ibadat, did the Prophet ﷺ leave room for us basically to improvise? Not much room. People fight all the time about how you're going to do this because there are so many hadith about how you're going to do this. So they can't stop fighting over it. But in the area of mu'amalat, you have principles, financial transactions, much less regulated. We said marriage is between the two, between ibadat and mu'amalat. There is still room, for customs, but less so than mu'amalat, and certainly much more than ibadat. Then the second is tafsir wa taqyid wa tasheeh kalam al-nas wa mu'amalatihim, interpreting, qualifying, and validating people's speech and transactions. An interaction that happened between me and you, a particular discussion that happened between me and you, a promise, a vow, an oath, a waqf, etc. I need to figure out what was meant, what was said, what was meant, what it means, what it implies, legal consequences of this, and I can't figure all of this out without referring back to customs. We're actually, I was involved in arbitration, I was not basically doing the arbitration, but the people who were doing the arbitration were consulting me, and I kept on telling them, you have to bring in someone familiar with customs in that particular profession, because there's a disagreement between two people within a particular profession. You have to bring someone who's familiar with the customs of the people in this particular profession and refer to what they say regarding this and this and that. There are certain things that are like Islamic principles that must not be violated, but at the end of the day, much of the arbitration will be determined on the basis of customs. So if you lack understanding of the Sharia, everything will be about customs. So it's like they call it in Egypt قعدة عرب يعني. It's like قعدة عرب means what? Like it's a setting of Arabs, like people referring to Arab customs, it's like they're sitting together and figuring it out. They wing it based on their understanding of their own customs and habits and stuff like this. And if you don't understand the customs, you will show a lot of rigidity. You understand the Sharia, but you don't understand the customs. May I say that sometimes you will be more harmful than the people who don't understand the Sharia and understand the customs? Sometimes you're actually more harmful. Sometimes you're actually more off the mark than the people who understand the customs, but they don't understand the Sharia. Because what they will get from the Sharia is basically general principles of justice and stuff like this. But they understand the customs well, so they may be, they may be closer to truth than the person who understands the Sharia and fails to understand people's customs and practices. Don't cut this out and use it, because it's not just, it has to be understood within the context of everything we're talking about. But that is just to underscore the importance of understanding people's customs. Okay. The last thing is تغير الأحكام المبنية على العادات والتي ترتبط مناطاتها بها. Altering legal rulings that are based on customs and whose effective cause is tied to it. Sometimes legal rulings are tied to, the effective causes of the legal rulings are tied to certain customs, and that will have to be taken in consideration. These rulings will change with the change of customs. These rulings will change with the change of customs. That brings us to the end of this. Inshallah, we will take 5 minutes and come back at 9:10.